Welcome everyone. You know the drill by now. I'm going to let everyone log in from the waiting room and launch the closed captions. Okay, the closed captions should be up and running. So you'll see that little red box at the top of the screen, and you can click on that to follow along with closed captions. And this is being recorded, and the recording will be sent out to everyone who's registered along with the materials tomorrow, and it will also be posted on the Florida Legal Services YouTube channel. So I'm glad you could join us today. Today we're going to be talking about access to housing, disaster relief, and homelessness assistance programs for immigrants. And I want to thank Laura Pichardo-Cruz for connecting us with this topic and this fantastic national speaker. I'm really excited about that. Laura is the chair of the Public Interest Law Section Immigration Work Group. So once we get started, I'll post her email in the chat and a link to the PILS webpage for anyone who's interested in joining and helping do this important work. And today we have with us Kate Walz. She is a senior attorney at the National Housing Law Project, and she specializes in civil rights, federally assisted housing preservation, can't read my own handwriting, the housing rights of survivors of violence, and immigration. So I'm thrilled to have her with us today. And without further ado, I will pass this over to Kate.
Thank you so much, Christy, and thank you for the opportunity to join you all. I'm going to share my screen so that we can talk about this important issue. Okay, so we'll be talking today about access to housing, disaster relief, and homelessness assistance programs for immigrants and what advocates need to know. It goes without saying that this is an evolving area of law over the last year in particular. So it varies by program and source of funding. Some programs, immigration implications are subject to interpretation by the administering federal agency. Some programs' funds impose no immigration restrictions, and state and local governments are not free to impose their own restrictions on these federal dollars. This is, as I noted, an evolving situation given the recent change in administration. First, we're going to talk about the public charge rule. The public charge rule gained quite a bit of attention during the Trump administration when there was a new rule proposed in 2019 after non-regulation but guidance from INS that had set the rule since 1999. But first, the question is, who is subject to public charge? First, it's non-citizens seeking admission into the United States or an adjustment of status to lawful permanent residence. So it's actually a very narrow category of individuals that could be subject to the public charge rule. Who is not subject to public charge? So the following categories of non-citizens are not subject to a public charge determination: lawful permanent residents applying for U.S. citizenship, refugees and asylees, VAWA self-petitioners, survivors of domestic violence, trafficking or other serious crimes, special immigrant juveniles, certain parolees, or several other categories of non-citizens. And just as a way of stepping back for a second, public charge, that determination could ultimately result in a person not being able to gain eligible immigration status in the United States or being subject to deportability. Under the public charge rule that's been in place since 1999, under that guidance that was issued by INS, a public charge is defined as a person who is primarily dependent on the government for subsistence, as shown by either the receipt of public cash assistance, such as TANF or SSI, or institutionalization for long-term care at the government's expense. Under the 2019 rule, however, a public charge is defined as an applicant who receives one or more public benefits for more than 12 months within a 36-month period, and specific benefits were listed as subject to the public charge determination under this 12 to 36 month window. That included public housing for the first time, Section 8 for the first time, SNAP, Medicaid, long-term institutionalization, and cash assistance. So it greatly expanded the category of benefits that would be subject to a public charge determination. It was also subject to a new totality of the circumstances test, which was a prospective, forward-looking into the future determination to see if a person was likely to become a public charge at any point in the future. There were several legal challenges to the public charge 2019 rule advanced around the country, including a case that the National Housing Law Project is a part of. After President Biden became president, then the Department of Justice dropped its various appeals of several cases successfully challenging the public charge rule, including the case here in Chicago, where I'm based, that left in place a ruling from the district court, which vacated the 2019 public charge rule nationwide. In March of 2021, then, the Department of Homeland Security formally removed the 2019 public charge rule from the Federal Register. So to be very clear, the 2019 public charge rule that included that whole additional list of public benefits, such as SNAP, Medicaid, Section 8, and public housing, is no longer in effect. What is in effect now is the 1999 interim field guidance, which remains the current public charge policy until any further rulemaking. That, again, is public cash assistance, TANF and SSI, so federal cash assistance, or long-term institutionalization at the government's expense. It does not include COVID-19 relief, such as rental assistance dollars, which I'll talk about later in the presentation. If you go to the Department of Homeland Security's website, it will further explain why COVID-19 benefits are not covered, and it helps to sort of deal with a lot of what we saw as a chilling effect on immigrants who were afraid, even if they weren't subject to public charge, that any type of public assistance they got could subject them to the public charge rule. Now, various Republican attorney generals have challenged DOJ's dropping of the various appeals, including the case in the Northern District of Illinois here in Chicago. So there are motions to intervene and appeals of those motions to intervene happening in various circuit courts of appeals. We feel fairly confident, however, that that will not prevail because the Department of Homeland Security is moving forward with the proposed rulemaking, essentially mooting out any sort of past history as it relates to the 2019 public charge rule. So in August, DHS issued an advance notice of proposed rulemaking, which is out now. Comments are due October 22nd of 2021, so this Friday. You can go, and I'll put this link in the chat too, to the Keeping Families Together website that is co-led by the National Housing Law Project and the National Low-Income Housing Coalition. We have provided a template for comments to send out on the ANPRN. It's critically important that benefits counted under the public charge rule be limited to those that mean that a person has become primarily and permanently reliant on the federal government to avoid destitution, and that it does not include that longer list of benefits that were included under the 2019 rule. Now I'm going to talk about the housing, emergency, and homelessness assistance programs and whether or not immigrants are eligible for those programs. These programs are governed by two main federal laws. First, Title IV of the Personal Responsibility Work Opportunity Reconciliation Act and Section 214 of the Housing and Community Development Act. They provide the main limitations on federal housing, emergency, and homelessness assistance programs. So this will vary by program and type of assistance. If an individual must have what's called qualified immigration status, or can receive the support regardless of their status, or can receive aid if they're meeting certain exemptions under those benefits programs. So Section 214 limits eligibility for qualified immigrants in the following housing programs: public housing, project-based Section 8 housing, Section 8 vouchers, or sometimes called tenant-based vouchers or housing choice vouchers, Section 236, HODAG, rent supplement programs, the Section 23 leased housing assistance program, and the Section 235 homeownership program. Section 214 does not apply to the Section 202 program, the Section 811 program, the 221D3 below market interest rate program, RD's Rural 515 program, RD's 538 multifamily loan program, the home program, the housing opportunities for persons with AIDS program, the community development block grant program, the U.S. Treasury's low-income housing tax credit program, and a variety of McKinney-Vento programs, including shelter plus care, supportive housing, and transitional housing. So if you have clients who have questions about their immigration eligibility for the federal housing programs, the first place to look is Section 214 of the Housing and Community Development Act. It's an exclusive list, so it's not subject to broader interpretation. And what are qualified immigrants under Section 214? U.S. citizens, lawful permanent residents, refugees and asylees, parolees, persons granted withholding of removal or deportation, persons granted amnesty, or qualified victims of trafficking. Now, for T visa holders, while they're not explicitly listed under Section 214's categories of eligible immigrants as qualified victims of trafficking, including T visa holders, they are eligible for HUD subsidized housing. They fall under that category as a qualified victim of trafficking. This is because persons who've made a bona fide application for a T visa are eligible for federal benefits, including subsidized housing, to the same extent they are as refugees who are also eligible under Section 214. U visa holders, however, are not among the category of eligible immigrants under Section 214 of the Housing and Community Development Act. However, advocates should examine whether a U visa holder fits into any other categories listed in Section 214, such as a victim of trafficking. In December of 2016, at the tail end of the Obama administration, there was a memo issued by then HUD Secretary Julian Castro that interpreted that VAWA self-petitioners have what's called satisfactory immigration status under Section 214. In this memo, Secretary Castro said this interpretation was consistent with Section 214 and VAWA's objectives to enhance victim safety and to place non-citizen victims of domestic violence in the same position vis-a-vis immigration law as they would have enjoyed had they not been abused by their U.S. citizen or lawful permanent resident relative. And so if you have a VAWA self-petitioner as a client, even though they're not specifically defined under the statute in Section 214, you should refer to the December 15, 2016 HUD memo. There is with Section 214 what's called the mixed status rule, which also gained quite a bit of attention during the Trump administration. But in short, the mixed status rule allows families with a combination of immigration status as eligible and non-eligible to live in federally assisted housing, in this case, we're talking just about HUD assisted housing, if there's at least one household member who has eligible immigration status to be eligible for that HUD assisted housing. That can include a minor child. So the head of household could be someone without eligible immigration status, but the family can still live and be eligible for that HUD assisted unit. The rent is prorated to reflect the number of eligible persons in the household. Now, in 2019, HUD had proposed a rule that would have prohibited mixed status families to live together. Advocates were preparing to challenge that rule. It never moved forward into a final rule before the end of the Trump administration. So the current rule remains in effect, that mixed status families can live in housing that is subject to Section 214 as long as one person, including a minor child, is eligible for that housing. And then the rent would be prorated to reflect that. There are also immigration restrictions in the rural development programs. These are the housing programs operated by the USDA. Then in the 514 and 516 programs, you must be a domestic farm worker to be in those programs, and you must be either a US citizen, an LPR, or have an H-2A visa. In the 502, in the 504 programs, those restrictions essentially mirror Section 214, that you have to be a US citizen, lawful permanent resident, or meet the otherwise other categories of qualified eligible immigrant. And then in the RD voucher program, essentially the same rule. You have to be a US citizen, lawful permanent resident, or meet the other categories of qualified eligible immigrant under the Section 214 program. RD currently treats mixed status households differently from the way that HUD treats mixed status households. In the RD program, the head of household has to have eligible immigration status in order for the family to be eligible. However, the immigration status of any other household member is not evaluated, and there is no proration of rent. And so it's more affordable to families, but the challenge is, of course, you've got to have an adult member of the household who can be the head of household for that family in order for them to be eligible for RD housing. We have been told that RD intends to issue conforming regulations to HUD's mixed status rule, and so that eventually the mixed status rule in RD housing will mirror that of HUD assisted housing. Nothing has come out yet. I'll certainly be happy to alert you when it does. And so what are the unrestricted programs that have no immigration restrictions? That includes the low-income housing tax credit program, the 202 program, the 811 program, the Section 221D3 program, Indian housing, housing opportunity for persons with AIDS, the rental rehabilitation programs, HOPE 2, the Section 515 program, the rural housing preservation grants, and the Section 538 multifamily loan guarantee programs. Now I have an asterisk next to the Section 515 and 538 programs because there is currently an issue with RD's interpretation of both programs. In 2004, RD issued regulations that had the effect of essentially stating that 515 was covered by Section 214, even though it's not, clearly from the statute. My office, well, prior to me joining the National Housing Law Project, intervened and asked RD to remove those regulations, which were in the form of an interim final rule, from the Federal Register, saying that they were in conflict with federal law. A note was added to the Federal Register saying that those regulations were indefinitely delayed. So RD is acknowledging there is no immigration restriction or eligibility requirement for 515. However, there is confusion around the country with this program and whether or not there's immigration requirements. That is in part due to an RD handbook, which copies the federal regulations, but does not include the section indefinitely deferring that 2004 IFR. And so you may hear from 515 housing providers who believe, per the handbook, that they have, in fact, a requirement, a legal requirement to impose immigration restrictions. If you are hearing that, we would be happy to hear from you and to learn more. We have reached out to RD. They said that they are going to correct this issue, but it has been going on for some time. As well, in the 538 program, RD issued regulations that also incorrectly stated that it was subject to essentially the 214 requirements of US citizen, LPR, or otherwise qualified immigrant status. We have reached out to RD about this issue as well and raised the fact that they are not subject to Section 214. We have been told that these regulations will also be rescinded, but at this point, it has not happened. If you're hearing about immigration eligibility issues within this program, happy to hear from you as well about that. Then we have the Personal Responsibility and Work Opportunity Act, or PORA. The primary question there is it a federal public benefit? This will be determined by the federal agency administering the funds. A state and local government cannot impose their own immigration determination or restrictions on these federal dollars. It's vested as a responsibility of the administering federal agency. Even if it is determined to be a federal public benefit, however, funds can still be available regardless of immigration status if necessary for the protection of life and safety, if it's short-term non-cash, in-kind disaster relief, or the funds are administered by a nonprofit charitable organization. The qualified status under PORA include lawful permanent residents, refugees, asylees, immigrants paroled into the United States for a period of at least 1 year, individuals whose deportation is being withheld on the basis of prospective persecution, individuals granted conditional entry, or Cuban and Haitian entrants. Now let's talk about the homeless emergency assistance funds under PORA and whether or not they're subject to PORA. So first, the Emergency Solutions Grant. These programs are not subject to immigration restrictions, which include street outreach services, emergency shelter, safe haven, rapid rehousing, transitional housing owned by the grant recipient or the subrecipient. They can be considered non-cash disaster relief and programs necessary for the protection of life and safety. And they are most typically programs also administered by a non-profit charitable organization. However, transitional housing provided in the form of rental assistance based upon the applicant's income is not considered an exempted activity. So that these categories above, just so we're clear, are considered exempt under PORA, and there is no immigration restriction to provide street outreach, emergency shelter, safe haven, rapid rehousing, transitional housing. They are all considered exempted. But if it is transitional housing provided in the form of rental assistance, where you're determining the person's income as a condition of receiving that rental assistance, it's not considered exempted under PORA. Then we have FEMA. FEMA should be considered non-cash disaster relief, including crisis counseling and disaster legal services and other short-term non-cash assistance. Other types of FEMA assistance that are non-monetary would not be subject to immigration restrictions and would be considered programs necessary for the life and safety of the recipients. These programs could also be administered by a nonprofit charitable organization and would also then not be subject to PORA. For those cash assistance programs under FEMA, there is a determination that it is a federal public benefit still. but those households with non-qualified individuals can still receive the cash assistance if an eligible adult or eligible minor child in that household applies for assistance. So even though it is disaster relief, if it's in the form of cash assistance, as long as one member of the household, including a minor child, has eligible immigration status under PORA, the household can still apply to receive that FEMA cash assistance. Under the CDBG program, there are no immigration restrictions. Of the questions I receive around the country, this is one of the most typical that I've heard of many local governments who believe that they do have to impose an immigration restriction on CDBG funds. They do not. And then probably the top question I've received over the last year is the question of rental assistance, the coronavirus relief funds or the emergency rental assistance program. There are no immigration restrictions on the coronavirus relief funds or either iteration of the emergency rental assistance program. If you look at the statutes authorizing those dollars, Congress imposed no immigration restrictions on those dollars, where in other parts and provisions of emergency relief, Congress did. There's also been no interpretation by the federal administering agency, in this case, the US Treasury, saying that there is or is not an immigration eligibility requirement under PORA for these dollars. So Treasury has not said that this is a federal public benefit. There was also litigation brought last December. There was a decision issued last December in the case of Poder in Action versus the city of Phoenix, Arizona. In that case, the city of Phoenix had imposed its own immigration restrictions on coronavirus relief funds, these rental assistance dollars. And the advocates made the arguments that I've just made to all of you, that the Congress said nothing about imposing immigration restrictions where it did in other provisions of the statute, that the Treasury had not issued regulations determining whether or not CRF was a federal public benefit. And as a result, a state and local government was not free to impose its own immigration restrictions. The court did not go as far as that interpretation. What the court said is these dollars, CRF dollars, which is the equivalent under the current program, ERAT, meet the exemptions under PORA as short-term, non-cash disaster relief. And that because of that, the local government, in this case, the city of Phoenix, was preempted from imposing its own immigration restriction. A couple of things that the court did in that case that are important. The court said rental assistance has always been interpreted, such as the Section 8 program, where a tenant has a Section 8 voucher, to be a form of non-cash assistance, because the money ultimately is going to the property owner and is not direct cash to the tenant. Now, under increasing guidance from the Treasury, if you're following the ERAP program, state and local governments are free now to give that rental assistance directly to the tenant and to let the tenant directly apply because of the amount of resistance or failure to apply challenges that they've had around the country. We are arguing that that does not change the fundamental nature of the program, which is to pay rent, which ultimately gets into the hands of a third party. And the fundamental nature of the program when it was constructed was to provide rental assistance that goes to the property owner. And so having this exception to it when property owners are not applying or not taking the funds directly doesn't change the nature of the program. And so it is still not subject to PORA. And I'm sure we'll have more questions about that, but that, just to be really clear, there should be no immigration restriction imposed on emergency rental assistance dollars under CRF, ERAP 1 or 2. And they're in state and local governments, even if you have a state law that looks like a state PORA, are not free to impose their own immigration restrictions on their dollars, because PORA says the agency that has the authority, the only authority to interpret immigration eligibility, is that federal administering agency, which in this case is the Treasury. And their silence means that there is at this point no immigration restriction. Now let's talk about the home program. While there was a 2004 question and answer where HUD said that the home program is a federal public benefit, it can be argued that because it's not a formal rulemaking, something that would be proposed and placed in the Federal Register, that is actually not a sufficient determination by the federal administering agency. But you could still argue that home dollars are non-cash disaster relief and programs necessary for the protection of life and safety. And most of the home dollars are administered by a nonprofit charitable organization. Now let's talk about energy assistance funds and a new category of water assistance funds. Under the LAHEAP program, unfortunately, it has been determined to be a federal public benefit. There are exceptions, however. The weatherization programs in multi-unit building where at least 2/3 of the residents are eligible, or in a 4-unit building where half of the residents are eligible, that program can still be applied to those buildings. If the LAHEAP dollars for energy assistance are administered by a charitable nonprofit, that charitable nonprofit is not required to inquire about the eligible immigration status of applicants. Or if it's other energy assistance not provided to individuals or households directly on the basis of their income eligibility. That would be something, for example, like a cooling center that anyone could enter without a question about their income eligibility or their immigration status. There has been a new program created by the Congress, first in late 2020, and then it was renewed under the American Rescue Plan Act in 2021. And this is the Low-Income Household Water Assistance Program. This came out of recognition that during a global pandemic where hand washing was key, there were low-income families that had their water shut off because they could not afford to pay their water bill. And so Congress created this program and then reauthorized it through ARPA. And it's targeted to low-income households who need water assistance to pay, need financial assistance to pay for their water. And there was a direct recognition in the language about this being during a pandemic, and Congress directly tied the need for this program to the public health crisis. In the statutory text, in both cases, Congress imposed no immigration restrictions. Unfortunately, we've recently uncovered that the Administration for Children and Families, in a frequently asked questions, stated that the Low-Income Household Water Assistance Program was a federal public benefit under PORA, and even imposed a 5-year wait, which is typically only imposed on federal means-tested public benefits. We believe this analysis is incorrect. However, until this changes, a couple of advocacy pro tips. It does say under the FAQ that as long as one person in the household has eligible immigration status, and this includes a minor child, they can apply for the water assistance funds. And that at a minimum, they should fall under the exceptions to PORA that I've talked about, which includes that this is short-term, non-cash disaster relief. These are dollars specifically granted during a public health disaster, and they are short-term. They are not extending beyond a year, which would be considered short-term under other interpretations by administering federal agencies. And it's non-cash because the money is going to the water company or the municipality administering the water and not directly to the family. And then let's talk about the Federal Privacy Act and Social Security numbers. Part of the reason I'm here today is I have heard from advocates around the country and in Florida that especially when it comes to the emergency rental assistance programs, many of those programs are requiring tenant applicants to supply a Social Security number as a condition of completing that application. That, as you know, has the effect of essentially imposing an immigration eligibility test on whether or not you can apply for those dollars. But separate from that, it also runs afoul of the Federal Privacy Act. At 5 U.S.C. Section 552, Note A, there's a provision called Disclosure of Social Security Numbers, and it provides that it shall be unlawful for any federal, state, or local government agency to deny any individual any right, benefit, or privilege provided by law because of such individual's refusal to disclose his Social Security account number. So at a minimum, if there is a category on an application for ERAP funds requiring a Social Security number, the applicant should have the ability to leave that blank. And so some advocates around the country have been able to do that they've been able to add a clause to that application to say you can leave this information blank. We continue to be concerned, however, about the chilling effect that people are afraid that if they don't have a Social Security number, they shouldn't be applying for these dollars, that they are deemed ineligible. So the best thing for a state or local agency administering these funds is to simply remove this number, the Social Security number question, from the applications. And we have been talking to the Department of Justice about this issue, and they are interviewing some of the advocates in the various states, including Florida, about this concerning problem, because we think it does violate federal law. There's nothing in the statute that authorizes the use of Social Security numbers, and state and local governments are not free to impose their own determination of eligibility or additional questions. I think this probably came from the fact that well-meaning agencies that typically do ask for Social Security number for other benefits programs applied it in this case. I've also heard from local governments saying that they're doing it as a basis out of concern that they may get audited. We have been asking for some instruction from the Department of Justice or Treasury to clarify this. But if you're talking to an agency that is administering ERAP dollars and they have this requirement, you can send them this note that's also on the DOJ's website, and make clear that at a minimum, they should add language to the effect of that you can leave this question blank. You should also be looking if the agency is imposing other identification requirements. And some states and local governments, they're imposing that you have to have a driver's license, whereas you may not be eligible for a driver's license depending on your status. And so it has the effect of creating an eligibility barrier. Here's my contact information. It's easiest to reach me during a pandemic where I'm working at home, as many of you are as well, at my email address, kwalz@nhlp.org. And I'm happy to take questions. I am curious if there's time to just talk about how ERAP funds are being administered in your state or locality, and then what additional information or support do you need?
Thank you so much for all that great information, Kate. We really appreciate you coming to us with the national perspective and also some tips and tricks for getting around possible restrictions in Florida. If anyone wants to answer these questions for Kate, you can put it in the chat right now. And I'll give you a few minutes to do that while we take a few questions. And then we're also going to hear from Tatiana Pumphrey at the Legal Aid Society of Palm Beach County about their program to deliver these types of emergency relief to immigrants and how you can possibly replicate that in your own program. So the first question we had was way back towards the beginning. Could you go over again, what is a qualified immigrant?
Sure. A qualified immigrant is defined under Section 214 of the Housing and Community Development Act, or under PORA. And so it's a list, a categorical list of eligible immigrants under either of those laws. Let me just put this in the chat. So I'm just putting in the chat the link to the comment template for the public charge rule. If you have any time and ability this week to add your input on what the public charge rule should include, this is the week to do it. The comments are due on Friday, October 22nd. And so we have put together a template. So it's pretty easy to use, and then just to apply your personal experience. Let me go back in the slides and I'll see.
And I'll add all these links to the follow-up email because I know that we've posted a lot of good information. So I'll be sure to include that so you have it.
So I somehow can't progress my slides back, but you'll make these slides available, Christy.
Right.
Okay, so if you look at the slides, there's two slides, one on the eligible immigrant categories under Section 214 of the Housing and Community Development Act, and then another slide under PORA, what are the eligible immigrant categories? And so those are the two definitions of qualified immigrant or eligible immigrant.
Okay, perfect. And I just posted in the chat, the CLE number is 5637. Again, it's 5637, and I'll send that out tomorrow with the materials. And we had another question that you did already address at the end, but I think it bears repeating because it was just so eye-opening. What can we do if we see immigration restrictions on CRF or ERAP? We often see the requirement for a social security number.
Yes, so this is really problematic. And I will say that in the states that have been slow to get their dollars out, we are seeing a correlation that they also have immigration restrictions to their dollars, and they are imposing a social security number requirement. I'm happy to talk to you directly if you're seeing that. We've worked with advocates in Nebraska, New York, Connecticut, and South Carolina to draft letters that have gone to those state and local governments explaining that they are not free to impose their own immigration restrictions, that they are in fact preempted from doing so. We are also connecting advocates to the Department of Justice Access to Justice program. Excuse me. They are looking into the matter and also trying to reach out to state and local governments. I know in some cases, this is coming from a locality, perhaps out of fear, because under the prior administration, there was such aggressive actions against immigrants that people are afraid that this is actually something that they're supposed to do. While we do not have direct guidance out of the Treasury that I think could put this all to rest, we have been able to get some local officials on the phone with Treasury officials who will talk them through this and give them the sort of comfort that they need, that this is not a requirement, that there are no immigration restrictions on ERAP dollars. So if you're seeing this within your jurisdiction, please reach out. I'm happy to talk to you directly and think about advocacy strategies. I'm also happy to connect you to the Department of Justice, or to connect your local administering agency to someone within the Treasury. Oh, and then the last sort of pro tip would be to ask them at a minimum to say that certain questions can be left blank. And so if they say you have to say what your status is, they could add at the bottom of that, you can leave this information blank. Or if they're saying you must provide your social security number, they could change it to say you can leave this information blank. And that's been a compromise that some advocates have been able to work out with agencies. But happy to hear from folks about that.
That's great. Thank you for offering to connect with advocates directly. We did have one more question, and then we'll have Tatiana come on. And if Kate's able to stay a few more minutes, we'll see if more questions come in at the end for Kate or Tatiana. Clients who applied for asylum and are waiting for a response, are they eligible or not?
If you have applied for as an asylee, you are deemed eligible. And that's the same with T visa holders and with VAWA self-petitioners. It's at the stage of application. Thank you for asking that question. It's at the stage of application.
Okay, great question. I'm surprised by the answer, so that's good to know. Tatiana, if you're ready, you can go ahead and unmute, and we'll see if your video is working to give us a little overview of what's happening in Palm Beach County.
Hi, can you hear me?
It's a little hard to hear you.
Is this better? I'm sorry.
That's much better.
Awesome. Thank you so much for taking the time. I just wanted to speak as far as what we have done at Legal Aid of Palm Beach to basically initiate these funds for those of our citizens that are undocumented. We do specialize in rapid response rehousing, and it's through our Fair Housing project. We aren't really creative with our names, but we are getting the goal accomplished for our clients. So with this is our REAP3 program. Our REAP3 program specializes in getting assistance for renters who have been affected by the COVID-19 pandemic, and they are currently facing eviction due to that. I just have a very short presentation. I want to be respectful of everyone's time, so please bear with me. Eligibility requirements are that the client or potential client must not be a U.S. citizen or permanent resident. They can be here on a visa, whether it's a K-1 visa or not, whatever works best for them. However, they do need to show that they are currently suffering from a financial hardship due to COVID-19. They also must be a renter and are able to prove that they are a renter by furnishing a lease agreement or some sort of agreement for a room agreement or the entire apartment. We do help them to get financial assistance for both themselves and their families if they have anyone else in a different apartment who is unable to make their rent payments due to the COVID pandemic. These are the identification and documents that we do require from them. As I said before, we do request a photo identification. It doesn't have to be a social security card, but we do need to verify that the person that we are assisting and the client is who they say they are. We do request a lease agreement, as well as a 3-day notice from the client. If they don't have that, if they can provide us with communication from the landlord stating that they are falling behind on their rent, it is something that we do look for to specify that they are going through an impending eviction. We also need to show proof of financial hardship. So we look for bank statements showing that they're unable to make the rent payments. We look for a letter from their employer saying that they are closing or reducing hours or layoffs due to the COVID pandemic. And if they're unable to provide this information, we look for them to execute an affidavit stating that they either were self-employed or they have not provided that information because, as you know, they're undocumented, so they might not always have verifiable information from an employer stating that they were employed there. So if they have anything like an affidavit stating that they were working, but they're unable to work due to the pandemic, we do ask them to execute that as well. This is an example case of ours. Miss Sample Client is an undocumented resident. She lives with her 6 children in a 2-bedroom home. Prior to COVID-19, she was working as a maid. Due to the fact of COVID-19, she was temporarily laid off, I apologize. And 2 of her children also caught the virus. So she went from making about some sufficient wages to reducing and then having to work as a farmhand for about $400 a week, significantly reducing her income. So she did try to make payments for her rent, but she was still served with both, next slide. She was still served with both a 3-day notice as well as a formal eviction in the courts for her back rent that she owed. We did assist her with getting all of her documents together. We have a pot of money from both private donors as well as the ERAP program through the government, in which we were able to get her qualified for financial assistance for the back rent so that she can secure housing for her family. We have several of these cases, really great success with this program. So I definitely wanted to thank both Christy and Kate for letting me present this information to you to let you know that, we're doing it here in Palm Beach County. We are happy and willing to assist those throughout the county if they would like to start a program like this with their specific counties. And please do connect with us. You can reach us on Facebook, Twitter, and YouTube. Thank you so much, Christy, for your time.
Thank you, Tatiana. It's always great to hear about the good work people are doing here in Florida. And I did put Tatiana's email in the chat if you want to reach out to her directly. If you're not somewhere where you can write it down or see it, that's fine. You can email me and I'll connect you with her. I don't see any other questions. So thank you all for attending. And one more time, the CLE number is 5637. And don't forget to join the public interest law section and the immigration work group. I put the link in the chat. And thank you again so much, Kate, for joining us today. We really appreciate it.
Thank you so much.
Take care, everybody.
Bye-bye.
Have a good afternoon.